In today's video, we are going to learn how to apply the Occupiers Liability Law under the Law of Contract into a problem question. So I will first give you a problem question, thereafter explain the main areas under Occupiers Liability, and then explain how to structure your answer to a problem question. So this is the question. Linda visits a theme park operated by Funland Limited. While walking on a slippery pathway leading to the rides, she slips and fractures her wrist. The park had displayed a small warning sign at the entrance stating, "Caution, wet pathways during rain." However, Linda argues that the sign was not prominent and no other precautions were taken to prevent slips on the wet pathways. So the question is, discuss whether Linda can bring a claim under the Occupiers Liability Act 1957 and evaluate the defenses Funland Limited may raise. So this is the question. Basically, there's a person visiting a theme park and there was a warning sign saying that the pathways are wet during rain, so therefore to be cautious. However, Linda slips and falls in this slippery pathway and fractures her wrist. So the question now is whether Linda can bring a claim against Funland Limited. However, the defendant is arguing that there was a warning sign, but in turn, Linda is saying the warning sign was not prominent and no other precautions were taken to prevent any slips on this wet pathway. So let us now identify which law we have to apply. And this question is made easy for you by pointing out that you have to apply the law under Occupiers Liability Act 1957, but you can get questions where the question may not specify which act you have to use. So basically, you have to know that there are two acts which regulate occupiers' liability. The 1957 Act imposes an obligation on occupiers with regard to lawful visitors. So whenever a lawful visitor is concerned, it is the 1957 Act that you have to apply. And 1984 Act imposes liability on occupiers with regard to persons other than his visitors. Or in other words, you can say it imposes a liability on occupiers for trespassers. So 1957 Act is for the lawful visitors, while 1984 Act is for trespassers. So you have to choose which act applies according to the given situation. However, here the question itself specifies that you have to apply the 1957 Act, so it's easy for you. So let us first look at the most important points that you have to include in your answer. Firstly, you have to know who is an occupier. So under the Occupiers Liability Act 1957 or 1984, there is no definition given for an occupier. However, we have an important case that is Wheat and Lacan, where the judges have defined an occupier as a person who exercises an element of control over premises. And it is not necessary for a person to have entire control over the premises. Just some degree of control will be sufficient for that person to be considered as an occupier. So next question is, who is a lawful visitor? There are 4 categories of lawful visitors identified under the Act. Those are invitees, licensees, those who enter pursuant to a contract, and those entering in exercising a right conferred by law. So invitees are like the friends that you invite to your house, your relatives, anyone you invite to your place, that's an invitee. And licensees are the ones who enter into premises with express or implied permission. For example, a person entering a shop, they're not invitees, but they have the permission to be there, so they become licensees. And third, we have those who enter pursuant to a contract, like a tenant who enters premises under a lease agreement, or it could be someone entering a movie theater by buying a ticket. So there is a contract pursuant to which the person enters the premises. and that makes him a lawful visitor. And also there are people who enter by exercising legal rights, such as a policeman with an arrest warrant or a search warrant. So they have a legal right to enter the premises. So all these four categories of people are referred to as lawful visitors. So the next question is, what are premises? Section 1, subsection 3, paragraph A of the Act defines premises as any fixed or movable structure, including any vessel, vehicle, or aircraft. So all these are considered as premises according to Section 1, subsection 3, paragraph A of the 1957 Act. And then the most important question, what is the duty of care owed by an occupier towards his visitors? This is explained under Section 2, subsection 2 of the Act, which says there is a duty imposed on an occupier to take reasonable care to see that the visitor will be reasonably safe in using the premises. So the duty of the occupier is to take reasonable care and to ensure that the visitor will be reasonably safe in using the premises. And now we know that an occupier owes a duty towards a visitor. Then what is the standard of care expected? So the standard of care is that of a reasonable man to guard against reasonably foreseeable risks, and the duty is to keep the visitor safe, not to maintain safe premises. That is very important to understand. The standard of care is that of a reasonable man. That means you have to apply an objective test here to see what is the standard of care that is expected of a reasonable man in similar situations. And then you do not have to make sure that the premises are entirely safe, but the occupier should just make sure that the visitor is safe on the premises. So that is the standard of care expected from an occupier. So there are several ways to avoid liability by an occupier. Firstly, we have warnings explained under Section 2, subsection 4, paragraph A of the Act. So if a warning is there, you have to make sure that the warning is enough to enable the visitor to be reasonably safe on the premises. And the warning has to be clearly visible to be effective. And the warning must cover the danger that in fact arises. Also, there is no duty to warn against obvious risks. So these are some points you need to remember when it comes to warnings. And second way to avoid liability is the exclusion clauses, which is explained under Section 2, subsection 1 of the Act. So according to this section, an occupier is entitled to rely on constructive notice by taking reasonable steps to bring any exclusion of liability to the attention of the visitor without the visitor actually being aware. So that means an occupier is not expected to give actual notice of the exclusion clause, but constructive notice is sufficient. This means the occupier just has to take reasonable steps to bring the exclusion clause into the notice of the visitor. But if the visitor doesn't read the clause or he just ignores the clause, then it is not the fault of the occupier. The occupier still can rely on constructive notice to avoid liability. And also exclusion clauses are unavailable where the persons enter under a legal right, and it will probably fail against children who are unable to understand the exclusion clauses. And where the occupier is a business, as in the question that we just read, the ability to exclude liability will be subjected to the Consumer Rights Act 2015, and earlier it was under the Unfair Contract Terms Act, but now the Consumer Rights Act will specify the situations or the restrictions on the use of exclusion clauses. So finally, we have to look at the defenses available. There are two main types of defenses. Firstly, we have voluntary non-fit injuria, or in other words, voluntariness of the claimant, which is described under Section 2, subsection 5 of the Occupiers Liability Act 1957. So here you have to show that the risk was fully understood by the visitor And it was not just the mere knowledge of the risk, but the visitor totally understood the risk. And also, if the claimant means the visitor, had no choice, then their consent cannot be used as a defense. For example, if a visitor had no other choice but to take up a risk in order to enter a place, then you cannot use volunteer as a defense. And secondly, we have contributory negligence under the Law Reform Contributory Negligence Act of 1945. So here the defendant will argue that the claimant's behavior was below the standard of a reasonable person, and that has contributed to their loss. So this is a partial defense. This will not avoid the liability of the defendant, but only a portion of the damages will be reduced in order to reflect the contribution to the loss by the claimant himself. So going back to our question, if you want, just pause and read it again in order to recall the facts of this problem question. So this should be the structure of your answer. Firstly, you have to identify who the occupier is. So explain who is an occupier, as I explained earlier, with reference to the case of Feed and Lacan. Then you have to identify who is the occupier in this particular question. So that is Funland Limited. And who is the lawful visitor, to which category Linda will fall, whether she's an invitee, licensee, or someone entering pursuant to a contract. So here we can see that he has entered a theme park. If she has brought a ticket and entered, she could be considered as someone entering pursuant to a contract. But if she has freely walked into the theme park, we can even consider her as a licensee. So it's up to you to identify which type of lawful visitor she is. And then premises, explain what premises are according to the Act. And here the theme park can be considered as premises. So that is the initial thing that you have to do in your answer. And then identify what is the duty of care owed by Fund and Limited to Linda according to Section 2, subsection 2. Then next, what is the standard of care? As I explained, that is of a reasonable person. So explain what is the standard of care. And then, has Fund and Limited fulfilled the standard of care expected? So for that, you have to explain the law on warning signs. So is giving the warning sufficient here? Or is there something more that Fund and Limited could have done? For example, anyone entering the theme park during a rainy day may have to take the walking path if there is no alternative path to take. So then, can this Fund and Limited do something extra, like put in some mats or put in a carpet so that the people will not slip? So is giving a warning, a small warning sign, sufficient to fulfill the standard of care of a reasonable person, a reasonable company who maintains such premises in a theme park? So you have to discuss that. And then, what are the defenses applicable? So here you can consider contributory negligence. Did Linda take sufficient care to make sure that she doesn't slip, or did she do something negligent which resulted in her slipping? So those facts should be considered in order to see whether there is contributory negligence. And if that applies, Fund Unlimited will still be liable, but the amount of damages awarded could be reduced. So after writing all that, you can come to the conclusion, can Linda succeed in her claim? So what's most important is the conclusion that you reach at when saying whether the warning is sufficient or not. And also you can say that this is an obvious risk because during rainy days, slipping on a walking path is something expected. It is something obvious, but the issue here is Fund Unlimited as the occupier should do something more in order to make sure that the visitors are reasonably safe for the purposes for which they are on the premises. So on that line, you have to argue that Fund Unlimited could have done something more, and the warning sign may not be sufficient because Linda especially argues that it was not prominent, it was just a small sign. So just giving a warning will not take away the liability of the occupier if it is not sufficient to make the visitor safe on the premises. So this is the situation as such. Therefore, you can come to the conclusion that Linda may succeed in her claim, but if she was negligent and if she has done something negligent and not taken care of herself, which resulted in the injury that she suffered, then the defendant may be able to claim contributory negligence in order to reduce the amount of damages. So that is the structure of the answer. And remember, I have not discussed the case laws here, which is very important. And in the next video, I will explain you some of the main cases which applies so that you can include those into your answer. And also, if you think that a model answer would help you further to understand how to write an answer for this question, please let me know in the comment section so that I can provide that too. So thank you for watching the video and stay in touch for further videos.